to the Super Morning Show. I hope you are doing well this morning, sir. Before I get to engage you on what's happening going forward, let's now listen to Dr. Tenuedu on the development so far.
The Speaker did not acknowledge the Supreme Court ruling. He said he's been notified of the Supreme Court's ruling.
That is acknowledging it?
Yes, but he did not acknowledge the legality of the Supreme Court's ruling. That's why they went to file papers at the Supreme Court today. But what has happened is that the Attorney General, I understand, has filed for the proper interpretation of Article 97. This is the proper application to the jurisdiction of the Supreme Court. What happened with the majority or minority leader, Anthony Markin or whatever, amounted to just an interference in the parliamentary proceeding. Now they are asking for interpretation of the article, which is within the jurisdiction of the Supreme Court. But it must be noted that the Supreme Court must adopt a purposive interpretation. What was in the minds of those who framed that provision? The Supreme Court cannot construe the interpretation. If it construes it, it is going out of its jurisdiction. There is a reference point for purposive interpretation, and that is to the Hansard of the Consultative Assembly that debated the provision. Then you will know what was the intention of those who framed the constitutional provision. The court of competent jurisdiction cannot overstep the boundaries of its legality to go and interfere with parliamentary proceedings. The Supreme Court's jurisdiction does not lie with interference with parliamentary proceedings. Then the Speaker was wise then, in which case, as he said the first day before the motion was moved in Parliament, if you sow evil, you reap evil. The MPP has sown evil and they are reaping evil. Now I understand they are calling for a resumption of Parliament.
Do you support the Speaker's decision to adjourn the House indefinitely, knowing the circumstances?
Yes, because what the MPP did was to suspend the Speaker's application of the standing orders by which the Constitution declares automatically that the seats are vacant.
Super Morning Show. 53 minutes past the hour of 8 here on the Super Morning Show. You heard there Dr. Tenuedu. And Dr. Tenuedu was giving us his opinion, his understanding, his appreciation. And of course, he spoke to us here and actually raised some of these issues and proceeded after the Speaker's decision to back the Speaker and insist that there is some interference from the Supreme Court of the Republic of Ghana. But now, let's take a step back, right? I mean, I did say that I had Dr. Justice Shremsai to join in this conversation. He's a senior lecturer in constitutional law at the University of Ghana School of Law. Now, Mahama Yariga is a member of parliament for Boko Central. Gentlemen, you're welcome to the Super Morning Show.
Yeah, thank you very much.
Let me start with you, Honorable NP. For those of us who follow but do not have a proper understanding of what exactly the Speaker said, the Speaker admitted that his office had been served a certain decision. He moved on. In fact, he didn't say anything like, this decision is binding on me, so I'm not doing anything contrary to it. He didn't say anything like that. He then proceeded to talk about the reactions surrounding what's supposed to happen in the House yesterday. Then he moved the conversation into consultations he's done and the decision he's come to after raising all the quorum and the other issues. What in a snapshot does it really mean to your work in Parliament? A Speaker saying that those 4 members of Parliament are still members of Parliament. Has he made any such decision? Yes.
Speaker,
Honorable Yaga, yes.
Speaker has not said that he has changed his position from what it was on Thursday. So I don't even know the basis on which you are questioning what the position of the Speaker is. The Speaker communicated his position on Thursday very, very clearly. On Tuesday yesterday, he did not say that what I did on Thursday is now I'm done. So I don't even know the basis on which you are questioning what is the position of the Speaker now. If he has a new position, he will tell all of us. So until he tells you that he has a new position, you are to act on the prevailing position, which is that he has declared 4 seats vacant. He has not come back to the chamber to say, I hereby revoke my earlier communication to you that these 4 seats are vacant. So it's a very simple matter. But the 4 seats remain vacant until he says otherwise.
Let me get this point clarified from you. When he started speaking, he admitted receipt of that decision from the Supreme Court. And I'm sure you agree that the decision of the Supreme Court is to stay the Speaker's declaration of those seats vacant. So by admitting it, is he not saying that it is coming to effect and that those seats are no longer declared vacant?
You see, we are adopting a very, very simplistic approach to the situation. The court is directing the Speaker to stay. But the Speaker has not said that he will stay. In fact, the Speaker may disagree with the court. He may keep doing what he is doing and go to the court to tell them, I disagree with you. Review your decision because I will not comply with your decision because it is wrong. And if you insist, I would go through the legal processes also, seek a review of your decision. So it's a long drawn process. But until he accepts and communicates to the House that he has accepted and will stay, the position that remains is that those 4 seats are vacant. And that is how we will act. We will act based on express communication from the Speaker, not implying things. No, we will not imply anything. We will act on the basis of express communication coming from the Speaker. And then we will follow. Whatever it is, we will follow. Just as yesterday he adjourned the House, we didn't insist that we must sit there. So we all got up and dispersed. Because under the Constitution, he's the one given the power to preside. He's the one who tells us what to do and what not to do. Not the court. The court communicates to him. If he accepts it, then he communicates to us. If he doesn't accept it, yesterday he didn't even go into the details of what the court told him, if you recall.
Yes.
He only said, I have received some processes from the court. Okay?
Mm-hmm.
So he was so careful that he didn't even tell us the content of the processes so that the content of the processes will become part of the record of the House. No, he didn't. He only said, I've received some processes. So they remain processes, so far as we MPs are concerned.
Let me bring in Dr. Justice Samside. If you join us here, and this is only 9 o'clock, you sure would know this conversation is about what happened in the Parliament of the Republic of Ghana yesterday. We are seeking to understand because as I've been having this conversation with the Member of Parliament for Boki Central, the understanding. Did you also get the understanding that the Speaker was acting on a directive from the Supreme Court which is binding on Parliament? Dr. Samsai.
Yeah, let me say good morning to my senior brother, Honorable Muhammad Yaraka. Now, to your question, I did not get such impression. I think we should take the Speaker's word as he spoke them yesterday for what they are, rather than try to imply into what the Speaker has said. The Speaker was emphatic that he has received processes from the court. Now, he did not go into the processes. He did not say anything about whether he will comply with whatever, because we don't know what processes he has received, at least on the floor of the House. Now, if we all know what happened in court because we have the record of proceedings and we have the ruling of the court. So we are entitled to also imagine what the Speaker would have done. From that perspective, we can see that the Speaker wanted the House to be properly constituted before he could go into whatever he had to, or whatever process he received, and what he would do with such a process. But let's look at how Parliament works. You see, Parliament works by, deliberations and then taking decisions. Okay. Whatever processes the Speaker received and whatever directive or orders were in those processes would definitely require a decision of Parliament and not necessarily the Speaker's own personal, conduct. But can the Parliament take such a decision, or could Parliament take such a decision yesterday? I don't think so, because as at yesterday, when the day ended, Parliament was not properly constituted for business, that is for taking decision. Because for Parliament to take a decision, it has to be, about one half of the members, all the members of Parliament, should have been present for a decision to be taken. But yesterday, it doesn't look like we had that number of persons in the House for the House to take a decision, because at least one thing we know is that one half of the membership had decided that they will not join the House. And in the absence of that one half, regardless of the number of the other half, you wouldn't have the minimum number of persons required to take a decision. It would have been great and would have been more refreshing if the House was properly constituted for decision making. Then the Speaker would have opened whatever processes received and would have subjected the process to parliamentary deliberation and a decision making. But since the House was not properly composed for that kind of business, we were not helped at all, in the sense that we still are hanging where we were hanging before yesterday. And so we should be able to take that as it is, rather than read into what the Speaker would have done, or what he had in mind, or how he wouldn't have done. And so the question still remains, what would have happened in Parliament? But we know that the previous decision of Parliament, or the previous position of Parliament, was that the 4 members, the seats they were on, have been declared vacant. And if they are declared vacant, the implication is that then the members cannot come into the House to take those seats, and also that will affect the general balance in the House, because 3 of those members were from the former majority, and then 1 from the former minority. And considering that the numbers were almost split in the middle, that would definitely change the position, which is what we have, and that is what I believe we are still holding on to until such a time that the House is properly constituted to consider the orders of the courts and then make a decision on such.
Now, what happened is that Alexander Afenyomakin's case at the Supreme Court was that the allegation, the basis of the Speaker's declaration is unconstitutional. However, before the Supreme Court answers the constitutionality question, he asked the court to order the Speaker to reverse his declaration that the 4 seats are vacant. The Supreme Court said that Honorable Afenyomakin's allegation sounds good on the face of it and is worth investigating. However, since the investigation will take some time, the Supreme Court will stay the Speaker's ruling from coming into effect until the investigation is concluded. Now, if I want to just draw down to the point, does the problem make the order unenforceable? The problem you have enumerated previously, as in whether or not to use stay or reverse in this case, is the Supreme Court's order unenforceable by the conduct of Parliament or the lack of action in Parliament yesterday? Are there 2 orders pertaining, one in Parliament and one by the Supreme Court? One by the Supreme Court that has not been enforced.
Well, yeah. So, if we take the Supreme Court's order on the face of it, it is simply saying that the courts, Parliament should stay the execution of its declaration. Mm-hmm. And I think that the court's using of the word stay was, in a way, ineffectual because what the court was seeking to stay from happening had already happened. So the previous day, which was the 17th, Parliament declared the seat vacated, and then the balance in the House, changed, so that the former minority became majority, and the former majority became minority. Okay. So if the court is making an order which is directing the speaker to stay the execution of that declaration, that could not be something that would be done because it has already happened. The changes have already occurred, and in fact, it's based on those changes that the plaintiff, that is Honorable Afinomaki, went to the court to ask the court that, look, this is what has happened in Parliament, and I'm asking you to reverse. So the order is, as it stands, on the face of it, has some problems. But when you read the order together with the proceedings that are in court, the processes that were filed in court, you could see that the stay could be replaced with the word reverse. Now, when the word reverse is replaced with a stay, what is going to happen is that then Parliament would have to take a decision for the reversal. That it would have been a different thing if Parliament was in the process of taking the decision and the Honorable Afinomaki went to court to stop Parliament, and the court said Parliament should stay. That way, then the stay would have, had an immediate effect, probably, freezing Parliament from going forward, right? But in this particular situation, the event had already happened. So if you're asking them to stay, that was not going to be possible. So until we read the orders broadly and replace it with reverse, which I think is the proper word or the proper order that should have been given, nothing could be done. Now, I believe that the order should be read broadly, especially when it is not in contempt proceedings. In contempt proceedings, because of the criminal sanction that comes with it, you could, you have to read it strictly to make sure that no one is punished on a vague order. But at this point where we are still not yet at the contempt level, we are dealing with situations of probably deliberation. If the order is replaced with reverse, then Parliament would have to act to be able to reverse. It is that action that I suspected was going to happen yesterday when the Speaker announced that he had received the processes. I suspected that if Parliament was properly constituted and there was quorum for business, I believe the Speaker would have opened the orders, read to the House, and even from the conversations that the two sides have been having, you could see clearly that there was going to be a discussion of whether the Speaker or whether Parliament should comply with the order, and if so, how to comply with it. That deliberation was definitely going to happen if the House was properly constituted. But unfortunately, we're not blessed with that deliberation. Okay. We're not blessed with that event because one side of the House decided not to show up at all. And that is where I see a challenge. Now, even if that side decide now to come to come into the House, into the chamber, and the other side, that is the NDC side, also decide not to come, we will still be where we are. So that is why some of us believe that when there's conflict in Parliament, it is a political conflict. And politics is always resolved or must always be resolved by political means. And when I say political means, I mean by deliberations, by negotiations, by discussions and diplomacy. I always have a problem when matters are happening on the floor of the House and some individuals either in the House or outside the House rush to court. Then what they are trying to do is to legalize a political process. And sometimes we misunderstand something in this town. Okay?
Before you move it, yes, I'll ask you about what the way forward is on this, but give me a second. Suggest that the ruling of the court needed some form of deliberation for it to be binding or for it to have the effect that it's supposed to have. But is that really the case?
No. So, like I said, the order itself is unclear on the face of it is unclear as to how to comply with the order. And it has always happened. If you recall, in the case of Abu Ramadan, those line of cases, sometimes the court makes an order, gives the directive, and the directive is almost vague, and no one, I mean, the party at whom the directive is made is unable to even understand and how to enforce the directive. In that case, there is a process called clarification. You can apply to the court to clarify to you that, look, these are the circumstances on the ground, and this is the order you have made. From the order you have made, it is almost impossible for me to comply with this order. So can you clarify the order in line with what the circumstances on the ground are? And that is also the danger in issuing, indefinite injunctive orders on ex parte motions. Because when you are going ex parte, it's only one side you are listening to. That is why the rule requires that an ex parte application should, when granted, ex parte injunction application, when granted, should last for a few number of days. And then the other party is given notice to come and present the side of the story before an indefinite order is made, interlocutory order is made. In this case, we did not see that. And that is the danger, because I'm sure if the Speaker or Parliament was put on notice, they would have brought certain things, to the attention of the court. For example, they would have probably told the court that, look, the order you are about to make would be capable of enforcement, because what we are trying to say had already happened. And if we go by the terms of the order, we may not be able to, enforce or even execute the order. So, and I believe that, so it is not a question of whether a court makes an order, you have to decide whether to obey the order or not. That is not what I'm saying. What I'm saying is that when a court makes an order, which on the face of it is unclear, definitely you would have to seek clarification. That clarification could happen, and the members of Parliament could come to an understanding on the floor that in order to do X, Y, Z, let's do this particular thing. And if the House is unable to, find a way out, the House can actually decide that let's go back to the Supreme Court to seek a clarification of the order vis-a-vis what is on the ground. So that is the point I was trying to make, not to say that you can deliberate and decide whether to obey the order or not, but you can deliberate to decide whether you understand the order and how to comply with the order. And if your understanding is still not clear, you can go back to the court and seek a clarification as to how the order should be complied with.
I know you have said, Mahama Yariga, I know you have said that to your mind, this is a directive that was given to the Speaker, and you as members of Parliament are not in the known of it. But this is something that's brought to the attention of everybody in this republic. We have published it, it's basically everywhere else. Are you saying that you also think the order is unclear and it requires some form of understanding and appreciation before it becomes applicable in your circumstance?
Oh, you have not been listening to me. I have never said the order is unclear.
No. I'm not saying
I have consistently said that the order is illegal,
that's not what I said.
Unconstitutional, has no basis.
Sorry,
in
I
our
am not saying you have said the order is
and
unclear.
Any practice that I know, because I have explained time and again that if you read Article 2 of the Constitution, which gives anybody the authority to go to the Supreme Court to seek a declaration that a conduct, an act, or anything is inconsistent with a provision of the Constitution. My view is that in relation to Parliament, what the court could have done is to expedite the process of making that constitutional determination, of declaring whether the conduct of the Speaker violates Article 97 of the Constitution. If they had declared the Speaker's conduct a nullity, then that would have been a proper exercise of the Supreme Court's jurisdiction. But somebody runs to the Supreme Court and says, the Speaker has declared seats vacant. We believe that the Speaker's conduct is in violation of the Constitution, which is Article 97 97G, 1G. Then you say, oh, well, we will take time to discuss the question of whether or not his conduct violates the Constitution. But in the meantime, tell him that he shouldn't go ahead with what he's doing. And I'm saying that interferes with the proceedings of Parliament. And there's another provision of the Constitution, Article 115, that says that the proceedings of Parliament shall not be questioned in any court. Any court. And that includes the Supreme Court. So, as for the proceedings, you cannot question it. But you can exercise your function under Article 2 to declare it a nullity. And like Prof has explained, the action has occurred already. The declaration of vacancy has occurred. It has happened. So the seats are vacant. What you can do as a Supreme Court is to expedite the process of taking the decision that the declaration is a nullity based on your reading of Article 97 of the Constitution. I have argued this severally. And I'm happy the way that Prof has also, tried to explain the fact that the action has occurred, the matter is done. So you can't say hold on with it because it's happened. And we've also argued that the conduct of the court itself is wrong because, like I say, Article 97 and any remedy that anybody can seek in relation to Article 97 is founded and directed by Article 99. Because 99 says that any question as to whether or not a seat is vacant, go to the High Court. And any lawyer will tell you that 99 is similar to 33. Because 33 follows the entire architecture of our human rights regime, which then says in 33 that if any of these provisions is violated and there's a question about them, go to the High Court. And the practice has been that when you go to the High Court and there is some serious contention as to what the words actually mean, then the High Court will stay the proceedings and refer the matter to the Supreme Court for them to guide them on what the words actually mean. So I'm saying that similarly, in this instance, Afro-Americans should have gone to the High Court. Then the High Court will say, well, under Article 99, any matter relating to Article 97, it is here you should come to. But I'm reading it this way, you are reading it that way. So let's send it to the Supreme Court to guide me as to how to enforce Article 97. So on every count, my position is that the Supreme Court is wrong.
Okay, but that was not the question I asked. I was asking you whether you agree with Justice Sermsai that the order, it was unclear. I was not saying you have said the order was unclear. That's the clarity I need you to get. Now, let me bring in something.
No, he, to tell you the truth, we learn from one another. And I'm happy to admit that I don't know everything. And I've listened to him, and, he tries to go into the mind of the speaker. I have tried to avoid trying to go into the mind of the speaker because the speaker has already been accused of being an NDC man, and if you listen to Afro-American on the airwaves yesterday, he kept accusing the speaker of conniving, of colluding with the NDC and saying he's doing the bidding of the NDC side. So if I attempt to go into the mind of the speaker and explain, I may be misconstrued as knowing what the speaker was going to do and how he was going to do it, and so maybe I had a hand in what he did.
Okay.
So this is Prof's appreciation of the situation. So I will leave it at that.
Now, Samson joins us. Samson's a lawyer, I'm sure you know, and he's also a journalist with us. Now, Samson, let's get clarity on what you think happened yesterday and how these parliamentarians perceive and others perceive what happened. To your mind, was the order unclear from the Supreme Court? That required some understanding by MPs before they could act on it. And the steps, if any at all, they were required to take Was that also dependent on clarity they got or were supposed to get from this order?
Right, Raymond. So let me begin by refreshing the memory of my respected senior, Mahama Yariga, when he said that the speaker only referenced a process that we do not know. Respectfully, the speaker identified the process properly and fully. He named the process as a ruling from the Supreme Court, and that was a ruling upon an ex parte motion by Afenyo Marking. And this is what he said. Let's read the speaker. He said, "Yesterday, I received the process from the Supreme Court, which is a ruling from the Supreme Court, pursuant to an ex parte application, directing Parliament to recognize and allow the 4 affected members of Parliament to duly represent their constituents and conduct the full scope of duties of their offices as members of Parliament, pending final determination of a suit filed by Honorable Alexander Afenyo Marking." Then he proceeded to speak about the fact that on the basis of Article 102 and 104 of the standing and 104 and also of the standing orders, order 64-1, they had quorum to commence business, but they could not take decisions. Now, Raymond, what I'm going to say has nothing to do with the propriety of the processes, has nothing to do with whether or not if you call it the rival interpretations that are being put on Article 97 and 99 has any directions on that. I have my views on that, and I'm very clear in my mind what ought to happen. But the ruling with the orders that came from the Supreme Court, whether the ruling or the orders, they are manifestly wrong, unlawful, or unconstitutional, they are binding on the Parliament of Ghana. This jurisprudence is universal, and it is to keep our polity together and to entrench our democracy. When you get a ruling from a court of competent jurisdiction or a judgment, and you disagree with it, you are not entitled to disobey it or ignore it. You do that on the pain of punishment. In fact, in Ghana, by Article 2, I think somewhere close is 434 thereabouts. This disobedience of the orders of the Supreme Court constitutes high crime that is punishable by up to 10 years in prison, and after service of 10 years in prison or whatever years you are given, you also are disqualified from public office for another 10 years. Now, if it is the president or the vice president who have disobeyed the orders or the judgment of the Supreme Court, it is a ground for removal from office. That is impeachment. So we put this in our constitution for a good reason, that we can always hold our society together so that our society will not be a place for survival of the fittest. Now, I do not have a history of any prosecution on the basis of any public officer disobeying a Supreme Court orders or ruling. And I think there will be a good reason for it. That even if maybe someone had disobeyed the court's orders, it may not be useful to trigger the process that will lead to, as it were, conviction for that kind of crime. Now, it is important, and I need to make this point. Okay. It is important that we understand that the ruling is not subject to deliberation or discussion in Parliament. It is not for Parliament to discuss it, to agree or disagree with the ruling. The same ex parte process that was used to obtain that ruling is available to set aside that ruling, except that if you are going to attempt to set it aside, it will be advised that you don't do ex parte, but you go on notice to the other party, regardless that the first party came without notice to you. And again, you could also file a process, even in addition to that, to try and stay execution of the ruling. And that application for stay will hold the hands, will bring the status quo ante, so that it will be deemed that the Speaker's declaration or information still stands.
Now, let me get this clarified from you. By the conduct, let me say, action or inaction of Parliament and the Speaker yesterday, did they disobey this ruling from the Supreme Court?
You can only suggest that there was a disobedience of the order if those affected members of Parliament attempted to enter Parliament and they were disallowed, or they entered Parliament and they were not counted when they had to be counted for whatever purposes, or they had to vote and their votes, were ignored and not counted. Or they wanted to make a contribution and they were disallowed from making a contribution on the basis of the Speaker's information to Parliament. To the extent that there is no evidence that they attempted to access Parliament and they were prevented, you cannot suggest, not by the stretch of any imagination, that the orders of the court have not been complied with.
So by merely stating, as Mahama Yariga has stated, that their understanding is that those seats remain vacant, they are not disobeying the orders of the court.
The Speaker has not said so. It must come from the mouth of the Speaker. Remember that the suit is the Speaker who is a defendant, together with the Attorney General. It is not members of Parliament. And it is the Speaker qua his office and not his person. So the Speaker you would discover mentioning that he has received it. And receiving the ruling, the order of the court, is all that is required, no more. Upon receipt of the order, it is in effect, full effect. So there's no need to deliberate or discuss or debate. I totally disagree with any suggestion that says that there has to be an opportunity, or there would be an opportunity for members to discuss and agree to it or not to agree to it.
Even
and
if
that there is anything
unclear,
to be reversed.
even if it is deemed unclear,
the order is an order for, so to speak, suspension of the implementation of the orders or the implementation of the decision of the Speaker. It's just suspension. There's nothing to reverse.
Okay.
Once the individuals enter Parliament, they will enter unless they are prevented. If they are, then that will constitute disobedience of the orders of Parliament.
we need to wrap up this conversation, and I'm grateful for you for your intervention, Samson Ladia, and on this point. Dr. Justice Semsai, you've heard Samson. Do you think that's the position of the law?
I would be humble enough to disagree with my very good friend Samson when he suggests that the order is clear enough and that anyone who prevents a person from entering the house and that the order doesn't require any action of parliament. The order requires an action of parliament, and as I've mentioned, if you ask that something be stayed, which has already happened, the only implied, one of the ways we can read it is to say that the things should be reversed. To enforce the order, it should be reversed. And he is using the word suspend. Well, that suspend is itself not in the order. So then, again, you ask yourself, how is he getting the suspend from? He is in the same position as me saying that reverse instead of stay. So these are some of the reasons why I believe that the order must be clarified, because from his own statement, he is replacing the stay with suspension, and I'm replacing the reversal. So clearly, there is a problem with the stay. He chose to go the suspend way, and I chose to go the reverse way. And I'm saying that based on these disagreements, even between the two of us now, the order must be clarified.
I get your point.
It is
forgive me, because I've just run out of time. I think we should continue this conversation. We should get to know in the subsequent days whether the majority is able to call parliament and what the appreciation of that particular directive from the Supreme Court is supposed to be. Many thanks to you, Dr. Justice Shamsai, Senior Lecturer in Constitutional Law, University of Ghana School of Law, Mahama Yaga as Member of Parliament for Bako Central, and Samson Ladia is our colleague and a lawyer too, with all the very interesting perspectives on it.